Okay, so maybe we will get started then. It's 11:03. I don't know if we should wait 2 more minutes, but since you started the recording, maybe we'll get going. So, good morning, everyone. My name is Elizabeth. I'm with National Tenant Network. I'm sure you're familiar with us. We've been helping REMAX Tri-County for years now. I see Mary is on the call as well. And today we're just going to be talking about the new law, in New Jersey that does affect how you run criminal information in the state of New Jersey. Um, there is a lot of information, and the process does need to change. So when you log into NTN, you probably have already noticed if you screened anyone since January 1st that the options are a little bit different now, and that's really to help comply with this new law. Um, Before I get into it, I just want to mention that there are some changes that are necessary. Nobody likes change, I get it, but there are local laws that are popping up all over. So in New York, they had the New York Housing Stability and Tenant Protection Act, which changed how you screen people in New York in 2019. In Philly, they recently had some updates that have changed how you screen people. That was probably about 3 months ago. And New Jersey, of course, now has this new law. So there are different laws up that affect how you screen people, but again, it's about complying. No one likes change, I get it, but in order to comply with the law, you do need to change, at least the process, not yourselves. As far as the information that I'm sharing, I just also want to make it very clear that I'm not an attorney. I've been in tenant screening now for about 10 years. This is my 10th year, but I'm not an attorney. So if you have specific questions, I might have to say, you got to speak to an attorney about that. It is a new law, and so there's no case law on it yet. So in some cases, it's best to just get direction from your attorneys or any attorney with association you work with. And then finally, I just want to say before I start that I did not write this law. It was by your lawmakers in New Jersey. And as they always say, do not shoot the messenger. I'm just here to inform you of it, to help you speak intelligently about this new law. But I did not write this law. So that being said, I just want to start off really quickly with this AG memo, which I'm sure you have seen. The AG memo went out and it was updated in December 2021. I'm sure you are aware of it, but before it said the laws against discrimination, but how they're enforcing this new law from the AG perspective is that they now have included it in the AG memo. So it now has the Fair Chance in Housing Act. So everything that I'm going to go over with you right now is all listed in here as far as what landlords are supposed to do, how they can use criminal records, the process, etc. And at the bottom, if you haven't seen, they've also updated to include a signature portion where not only the agent but also the landlord is required to sign. So I'm sure that you have to have your landlords, if it's your listing, have your landlords now sign this, and then you would keep it on file to prove that they did, say that they did receive this and they understand the information, etc. So this AG memo is the way that they're going to essentially, I think, enforce this law. Now, give me 1 second while I just set up my slides here. Okay. And I hope you can see the slides. If not, shout out at me. So we're going to talk today about the Fair Chance in Housing Act. I'm going to try to get through it as quickly as possible. If it's possible to hold questions to the end, or you can use the chat box as well if you have questions, that will work as well. And I am just, give me 1 second here. I just want to make sure everyone is muted. Okay. All right. So we're going to talk about the Fair Chance in Housing Act. So if we dive right in, the what, when, who of it. So if you don't know, on Juneteenth, 2021, Governor Murphy signed the Fair Chance in Housing Act, which also is known as the FCHA. And this bars housing providers from asking about criminal history on housing applications in most instances. The FCHA is the first law of its kind in the country and is intended to ensure people with past criminal histories have a fair shot at accessing safe and affordable housing. So if you think about maybe you have friends, maybe you have family members who have made a poor decision in the past and now have a criminal record, it is quite possible that they've had trouble finding a job or finding employment, finding a housing as a result of having this criminal record. So the spirit of this law is a good one in that it's about giving second chances. But again, as I mentioned, the procedures do have to change in order to comply. As an example, I don't know if you're familiar with Larry Miller. He's the chairman of Nike. When Larry Miller was younger, he actually said that he was in a gang in Philly. and he shot someone and killed them in retaliation. And he, served his time or his sentence, and then he basically rehabilitated himself, and now he's a different person, and obviously now he's a chairman of Nike. So I think this law is really, again, about second chances and about people actually rehabilitating themselves, changing, and giving people a fair shot with past criminal histories, at accessing the safe and affordable housing. Now, the bill, as Joan asked, is this in effect now? It is in effect now. So the bill went into effect on January 1st, 2022. It was actually signed into law June 2021. The bill went into effect January 1st. And the DCR, the Division of Civil Rights of New Jersey, released the guidance 2 weeks before the new year. So you can imagine that everybody has been scrambling to kind of get up and running and making sure their procedures are, in compliance with this new law. Just so you know, the housing providers subject to the FCHA include landlords, owners, lessors, sublessors, assignees, or their agents, or any other person receiving or entitled to receive rents or benefits for the use or occupancy of any rental dwelling unit. Now, some agents have asked me, what about seasonal rentals? What about short-term rentals? Just note that in the language of the law, they don't distinguish between length of time and the rentals from what we can see. So we imagine it would apply. This would be a great attorney question as far as seasonal and short-term rentals. Also, I've been asked, does this affect commercial? And again, in the language of the law that we see, it says rental dwelling units. It says occupancy. It says, or occupancy of any rental dwelling unit. It says residential purposes, but it doesn't say anything about commercial. So from our understanding, this does not affect commercial. But again, if you want to check, you could always check with an attorney. Now, there is one carve out, one exception to this that the DCR released in its guidance in December. So they said under the FCHA, a rental dwelling unit means a home offered for rent by a housing provider for residential purposes, except for a dwelling unit in an owner-occupied premises of no more than 4 dwelling units. So that's the only carve-out. If there is an owner-occupied premise that you're representing with no more than 4 dwelling units, they are not subject to the Fair Chance in Housing Act. But remember, it has to be both. The owner does have to reside on that property, and it has to be 4 units or less. Sometimes I've had agents call me saying, hey, is this landlord exempt because they only have 2 units and you said it was only 2 units. Remember, it's less than 4 units, so 2 units, yes, but also has to be owner occupied. So the landlord does have to reside on that property as well. It's an and situation, not an or situation. So just remember, owner occupied and no more than 4 dwelling units are exempt from this FCHA. So ban the box for housing. So if you know the term ban the box is used in the employment world. And what ban the box refers to is the box on an employment application that says, have you ever been convicted of a crime, right? And somebody has to answer yes or no. And so they call that ban the box because when they started ban the box for employment, it basically meant that an employer could not ask any questions into the criminal history or run any criminal background reports until after they give a conditional offer letter of employment. So effectively, they were banning the criminal question or banning the box for the criminal question, for the employment world. So what this bill is it's basically a ban the box, but it's for housing instead. So therefore, a housing provider cannot ask about criminal history prior to issuing a conditional offer of approval. Now, there are 2 exceptions to the questions that can be asked. A housing provider could ask in an application specifically whether the applicant has ever been convicted of drug-related criminal activity related to the manufacture or production of methamphetamine on the premises of federally assisted housing, and 2, if the tenant is subject to lifetime registration under a state sex offender registry. So those are the only 2 questions that could be asked up front. Just note that on NTN's application, we have removed criminal questions, and we do have a process for obtaining this information, but obtaining it at a certain point within the application process. We basically are asking criminal questions after the conditional offer letter has been provided. So what happens if an applicant volunteers information? So when applicants volunteer information, a landlord cannot ask about criminal history prior to a conditional offer, but the applicant could come in and they could provide evidence to the housing provider demonstrating inaccuracies within the applicant's criminal record or evidence of rehabilitation or other mitigating factors. So in short, you cannot ask about it, but the applicant could voluntarily provide it. So if a tenant does give you information or the landlord information up front about criminal history, the landlord should accept the information, but just not consider it until they're allowed to do so, which is after the conditional offer is made. After that, then they can start looking at the criminal information. So the process itself, from an agent perspective and what you're doing with NTN system, it's for the most part the same. There is a, when you go into the system and you're processing the reports, you're already defaulted for two reports. It's the NTN decision point report, and we are including the sex offender report, because remember, that's one of the questions, one of the things the landlords can review up front. So we are providing that report up front. And so when you process the report, you're just using the defaults in the system. You process the reports, those are the reports that will be run. And then later on, after the conditional offer letter is presented to the tenant, then you can just go back to that tenant in the NTN system and you can click add report to order. When you click add report to order, then it will just give you a prompt. You can add on the multi-state criminal report. It will process that, and then you will get the full report back with a criminal. But remember, the idea is what we call in the NTN world as tiered screening is what you're doing. So you're basically tiering out the screening. So first tier is going to be your NTN decision point and sex offender report. Second tier is going to be the multi-state criminal report, which is after the conditional offer letter is provided. When we look at the steps, overall, though, what has to happen now? So you have to provide the same online application link. It's the same link. It's the same application fee that you're sending to a prospective tenant. The only difference is we've removed the questions regarding criminal history, and also we've included this fair chance in housing disclosure language. So the Division of Civil Rights says that you must, the housing provider must provide the disclosure on the Fair Chance in Housing Act to the tenant so they know the process for screening. So we've already put that, we put that in your link before January 1st. So it's already in your online application link. So you're sending the application out as you normally would. And then you would jump into the system once you know they've completed it. And again, you're going to request or process the NTN decision point report. So again, you're going to be defaulted for what you can run up front initially. Once you run that information, you're going to provide that to the landlord, and they're going to do the preliminary assessment. So at this point, not using any criminal information, they're going to make a decision whether they're going to move forward and approve or if they're going to deny the tenant based on the information that they have. Again, not including any criminal information, they make an initial assessment. If they're going to deny the tenant based on the NTN decision point report, you can use the adverse action letter, or if you need an adverse action letter from NTN, we'll get you one you can use. Otherwise, if the landlord wants to approve and move forward with this tenant, the landlord has to give a conditional offer letter of approval. Now, we do have templates for this if you need it. I will send them over to your office. But if the landlord should also have it, and in that AG memo, there's a link to obtaining a model conditional offer letter. So the landlord essentially has to sign that. Another thing that NTN is recommending for our clients is the use of a secondary application, which inquires about criminal background checks and mitigating circumstances. So the secondary application is just a paper one. When you give the conditional offer letter to the tenant, you could also supply the secondary application, which then inquires into the criminal history because you're allowed to do it that way by law. Also, since the conditional offer letter has been presented, at that point you could jump back into the NTN system. You could pull up the name of your applicant, and you could add report to order and add on now the criminal report. If there are any criminal records that do come back, then the landlord has to perform an individualized assessment if the criminal convictions are found within the allowable look-back periods. And I'll talk about the look-back periods in a second. And at that point, the landlord's either going to approve or deny. So if they approve, you're just moving forward with the lease. If they deny the tenant, then there is a withdrawal notice that should be used. And again, we have a template for that. The DCR also does have a template, but just note that the DCR's template is only compliant with the Fair Chance in Housing Act. It's not compliant with the Fair Credit Reporting Act. So NTN's template combines both the Fair Chance in Housing Act required language as well as the Fair Credit Reporting Act language. So it might be better for you to use our language to make sure you're in compliance with the FCHA as well as the FCRA. Now, I know that this seems like a lot more because the landlord has to do a little bit of a two-step analysis now. However, in many cases still, and if you think about how many reports you ran that came back with criminal records, it's probably less people with, or more people that don't have a criminal record. So in that case, what happens is once the landlord conditionally approves, if there's no criminal record that comes back, then you're just going to move forward with the lease. So people who are already implementing this into their process, it's just been, moving forward as usual. It hasn't been too much of a hang up, so to speak. So it should be pretty clear. It's only in the case where there is criminal records that are reported that the landlord is going to have to take these additional steps in order to do this individualized assessment and ensure that, the tenant with a criminal history has a fair shot at the housing. Okay, so I talked about look back periods. So just so you know, as far as look back periods, so before this law, landlords could consider any records just as long as they followed the HUD guidance, which said you had to look at when did the offense occur, how serious was the crime, did the person do jail time or rehabilitation, and do they pose a significant threat to the neighbors. That still stands, and that's federal from HUD. However, what New Jersey did was they basically created look back periods for all the landlords in New Jersey. And so what they did was they looked at all the criminal activity and they separated them all. So they have specified heinous crimes, which are your really egregious crimes like murder, right? And then they have all the other criminal activity. It's all categorized by degree level. So New Jersey categorized its criminal records by degree. First degree being the most severe, then second and third, and then fourth degree crimes. And so for specified heinous crimes, there's an unlimited look back period. So a landlord could consider any specified heinous crimes indefinitely. They could look at them. So if somebody murdered someone 5 years ago or they murdered someone 55 years ago, the landlord could consider those records because they're specified heinous crimes. Otherwise, it depends on the degree level. So first degree has a 6-year look back period. Second and third degree crimes have a 4-year look back period, and fourth degree crimes have a 1-year look back period. So if there is a fourth degree crime that's committed and on the report, but it's 2 years old, a landlord cannot consider that, right? Because it's outside of that 1-year scope. Second and third degree crimes, same thing. If it happened, 7 years ago, they can't consider anything beyond 4 years. And same thing with first degree. They can't consider anything beyond 6 years unless it's a heinous crime. Now, just so you know, the look back period begins from the date the conviction was issued or the conviction resulted in a prison sentence, or if the conviction resulted in a prison sentence, from when that sentence concluded. So basically, if somebody was, let's say they committed a first degree crime and they were sentenced to prison for 6 years, the time for the look back period starts from the date of release of imprisonment. It doesn't start from the date they were sentenced, because if it started from the date they were sentenced and they were sentenced to 6 years, they could presumably just walk out of jail and then apply for the apartment, and the landlord wouldn't be able to use the records. So that's why the DCR clarifies that the look back period starts from the date the conviction was issued, or if it resulted in prison sentence, from the date that they were released from incarceration. Now, this information, again, is more information for your landlords because they're the ones who are making the decision and doing the individualized analysis. But I'm just giving you this information so you have an understanding of what the landlords do have to do now. Now, the heinous crimes, in case you're wondering what they are, it's murder, sexual assault, aggravated sexual assault, human trafficking, kidnapping, arson, causing or permitting a child to engage in prohibited sexual acts or in the simulation of such acts, and any crimes that result in a lifetime registration on a state sex offender registry. So these are all the unlimited look back period, the heinous crimes with the unlimited look back period. And then, as I mentioned, all the other crimes can only be considered within the allowable look back periods following conviction or release based upon the degree of the offense. Now, one thing NTN is doing to help our customers, because we do have researchers on staff, they're at least cleaning up the reports for your landlord. So when we get the criminal report back, if it's a heinous crime, we're going to leave it on the report. But if it's not a heinous crime and then it falls into any of these other degree level crimes, anything over 7 years, we're automatically removing from the report. So that way we're going to at least to help clean up how many records the landlord can use. And if they can't use it at all, well, we're removing it. But then whatever's left on that report, the landlord will have to check to see whether it falls within the degree. But we're at least removing all those older records that wouldn't be able to be used anyway, again, unless they're heinous crimes. So now your question might be, well, how is a landlord supposed to figure out what crime is what degree? Right? Well, that was a question that NTN had for the lawmakers, because NTN knows that degree levels are not reported on a criminal report. So how are landlords supposed to find this information out? Well, New Jersey lawmakers came back and said, we're going to make a master spreadsheet of all the criminal activity that could happen in the state of New Jersey. So now what the landlords have to do is when they get that report back, they will have to go to the website, the Attorney General's website. They're going to have to look up the actual offense, and then they'll find the corresponding degree code. And then once they have the degree code, they'll know whether or not they can consider it from the sentence date, within the allowable look back period. So again, this is all things that the landlord has to do, but the agent is probably not necessarily going to be doing this. And if landlords have questions about this, again, you can always send them over to the Division of Civil Rights homepage on the FCHA, or you could, the letter that was provided to them, the AG memo, also tells them where they can find all of this information. Just so you know, criminal activity that cannot be considered. So New Jersey categorizes its crimes as indictable offenses or disorderly persons offenses. So disorderly persons offenses, which are lesser crimes in New Jersey, or juvenile delinquencies are not defined as crimes in the state of New Jersey and cannot be considered under the Fair Chance and Housing Law. Additionally, housing providers cannot consider arrest records that did not result in a conviction, convictions that have been expunged or vacated, or crimes that are not defined as such in New Jersey. For example, those disorderly persons offenses. Our recommendation is that landlords should not use information from a Google or web search. A lot of times when you do a Google or web search, at the bottom in fine print, it will say, we cannot guarantee with 100% certainty that this belongs to your person. And, especially when you're Googling common names like John Smith or Jose Rodriguez, there could be a lot of records that come back because it's a common name. And that presents a problem if you're denying housing based on this information. In addition to this, I get calls from agents who tell me their landlord wants to deny someone because of a newspaper article. It said that this person was arrested. And, the problem with that is, again, you have to know what the actual result of the arrest was. You can't just go on the fact that they were arrested because they may not have been convicted of anything, right? So you just have to make sure you're using reliable information. And remember, NTN is getting this information from the criminal database, and we're also reviewing it to make sure it belongs to your person. So putting things into practice, just so you know, again, I mentioned there is certain required disclosure language that has to be on the application. There is a model notice that was provided by the Division of Civil Rights. And so NTN has already included that into the online application link. And so the tenant will get that information, and they're also going to sign consent that they have received and, read this information. So there's nothing really to do on your end as far as sending out. It's just the same application link, same application fee you're sending to the prospective tenant. As I mentioned, as far as the initial screening or that tiered screening, the first tier is going to be the decision point report and the sex offender report. And when you go into the system, when you go to process an application, you'll see it's defaulted for the decision point and the sex offense only. So just leave it as defaulted, and you're going to run that information. If you're asking for any proof of ID or proof of income, you can also still collect that information, and you would share that all with the landlord. And the landlord is then either going to move forward with the tenant, and they'll have to supply the conditional offer letter, or they're going to deny the tenant, and then you could give them a normal adverse action letter. Again, if you need it, you can just call our office and we'll send you one. And then, screening decisions must be made in a lawful, non-discriminatory manner. So that's exactly why the decision point is a good first tier, because, it's looking at all the applicants using the same criteria across the board for everyone. So it helps in making sure that, everything is being done in a lawful, non-discriminatory manner. So once the landlord, if they do decide to move forward, If you want to use, and again, I'll make this available to your office, there is a secondary application that NTN has a template of. And what it does is, because after the law says that you can ask criminal questions after the conditional offer letter has been presented, this secondary application allows the tenant to enter in that criminal background history. So the first question is whether any applicant has been convicted of a crime. And so, if they haven't been convicted of a crime, they can simply check off no, sign the bottom, they're done. But at least you ask the question. And why that's important is because if a tenant says no, but you end up running the criminal report and it comes back that there are records found, then the landlord could deny at that point for untruthful information, right? So they lied on the application. You're not even denying for the criminal information, you're denying because they lied on the application. But the application will allow the tenant to list any convictions, sentences imposed, dates of incarceration, if any, degree of offense, age when the crime was committed, whether the crime occurred on leased housing, etc. And then, as I mentioned, the applicant doesn't need to list any arrests that did not result in a conviction, any juvenile delinquencies, disorderly persons offenses, or convictions that have been expunged or vacated, because those are not allowed. However, the application will also provide an opportunity to provide mitigating information. So if the tenant wants to list that they did have a criminal record and any information surrounding it, they'll also have an opportunity to provide any evidence of rehabilitation efforts, any evidence of good tenant history following release. If they want to add any character references that, from a minister or a pastor, saying how, they have really rehabilitated themselves and they're, upstanding, person in the congregation or the society or whatever it is, they can add that additional information. So the reason this is important is because the DCR says that the landlord or housing provider must provide an applicant an opportunity to provide mitigating information. So the reason for that NTN is recommending the secondary application is because if there's ever a claim brought up where the tenant says, hey, I was working with this agent and their landlord and they never gave me a chance to provide any mitigating information, you would then have a paper trail to say, no, we actually did provide it. This was sent out, but you might have a note on it that it was not returned, by a specific date or whatever it is. So again, it's just a matter of making sure that you're covering yourself and having that paper trail. Although the secondary application is not required, it's highly recommended by NTN and also many of the lawyers and that work for the New Jersey Apartment Association and other property associations. When you get to the point for the criminal background report, again, it's just as simple as locating the applicant that you screened initially, and then there's an orange button that says add criminal report to order. Or I'm sorry, add report to order. So when you click on add report to order, it's just going to pull up the multi-state criminal report. You're going to check that off and then process that report. And then obviously if there is a record that does come back that's within the allowable look back period, the landlord is going to have to do some kind of individualized assessment. And they might decide to withdraw the conditional offer based on those crimes. And it does say that the landlord must perform an individualized assessment in a non-discriminatory manner. So in case you're wondering what that means, there was a question that was brought up in one of the landlords, property owners meetings, and the attorney there said that, maybe the landlord would want to form a panel of 3 people or something. That way you have a tiebreaker, but that way you also have 3 different lived experiences weighing in on this rather than it just being one person. So that would be an example of a way that a landlord could do the individualized assessment in a non-discriminatory manner. And they also mentioned that, if the landlord did do that, probably the landlord's attorney should not be part of that panel because, if there's a claim brought up, the attorney would be looped into it and wouldn't be able to represent the landlord. So the landlord's attorney shouldn't be part of that. And also, I'm sure as an agent, you wouldn't want to be looped into that either. But, just to give you an example of what other landlords may be doing in the event that your landlord asks. Again, it's always good to just refer them to their attorneys. Withdrawal notice, just so you know, the withdrawal notice that I mentioned, we have a template of. The landlord has to provide with specificity the reasons for denial when it comes to any criminal denials, and also has to afford the tenants an opportunity to appeal. So there is a model notice that was provided by the Division on Civil Rights. However, again, when NTN reviewed that, we noticed that although it was compliant with the Fair Chance and Housing Act, it was not compliant with the Fair Credit Reporting Act. So our template marries both, and your landlords could certainly copy, paste, and write fill out that that withdrawal notice if they are denying for criminal records. And then the landlord, just so you know, in this new law, normally anytime a tenant asks for a copy of the report, we always tell our customers, look, do not release it. Just send them over to NTN. They can fill out a request form and we will release the copy of the report. Now with this new law, there is something written in it that says the landlord must provide tenants with the opportunity to request all information used to screen the tenant, including information considered in criminal and non-criminal screening. So the applicants must request the information within 30 days of a denial, and the landlord must provide the applicant the information within 10 days of receiving such a request. So if the tenant is denied based on the decision point report that comes up, you can use NTN's adverse action letter. Again, if you need it, you can call us. We'll get you one you can use. Otherwise, if they're denied for criminal and criminal only, to comply with this law, if the tenant asks for a copy of the reports that were run within 30 days of that criminal denial, then you must provide a copy of the reports within 10 days of receiving that timely request. So just keep that in mind, that there's an actual law now that says you do have to release the reports when it comes to criminal denials. And that's the NTN decision point report as well as the multi-state criminal report. When the landlord does their individualized assessment, and again, this is on the AG memo to the landlord, the Division of Civil Rights did list out some factors that the landlord should consider as they're going through that individualized assessment. So the landlord should be looking at things like the nature and severity of the criminal offense, the age of the applicant at the time of the occurrence of the criminal offense, the time which has elapsed since the occurrence of the criminal offense, any information produced by the applicant or produced on the applicant's behalf in regard to the applicant's rehabilitation and good conduct since the occurrence of the criminal offense, the degree to which the criminal offense, if it reoccurred, would negatively impact the safety of the housing provider's other tenants or property, and whether the criminal offense occurred on or was connected to property that was rented or leased by the applicant. Now, as far as templates and documents, just so you know, there is the main disclosure notice. So I will send this over to your office as well. Again, this has already been put inside the NTN online applications, but if you wanted to give people a paper copy, we will make this available to you. The only thing I would recommend is that you do give a paper copy to everyone, because if you have any testers that come in and you give a paper copy of the New Jersey Fair Chance and Housing Act disclosure language to one and you don't give it to the other, that could be considered discriminatory, right? So you want to make sure you're doing the same thing for everyone. As far as processing the reports, as I mentioned, this is going to be, you're going to already be defaulted when you go to process the report. It's going to just be checked off on what you initially can run, and that's going to be the NTN decision point report, and it's also going to be the sex offender report. So you just leave this alone and you just hit next step, and then you get to the order confirmation page and you're just going to process the reports as normal. The conditional offer letter, if the landlord does decide to move forward, then there is a conditional offer letter. We do have a template that you can use, or again, in the AG memo, they have a link to a website that the landlord can use. And basically this lets the tenant know that in the preliminary assessment, they've determined that they're conditionally approved. But now, since they, since they've made that determination, they're going to be running the criminal background screening. And also here's a supplemental application to determine your final eligibility. So this conditional offer letter is a template that we will make available. If you do want to use the supplemental application, again, I'll make this also available for your office, but this is where it does ask into the criminal information and allows the opportunity for mitigating information. Also, we did include a return by date on here. You could edit this and format it however you want, but the return by date is really so that the landlord can set a reasonable date, maybe 2 business days or something, for the tenant to return this information. That way it still helps to expedite the process, and also it helps to, make sure that if they don't return it by that due by date, then the landlord could still do the individualized assessment with the information they have. They did give the opportunity to the tenant to provide the mitigating information, and they make their decision, and they either accept or they would withdraw that conditional offer. As far as step 2, so again, I mentioned there was an add to order. It'll either say add to order or add report to order. So either any one of these you would use. You're not adding an applicant, you're not sending out a report, you're just adding to order. So when you click on this, again, it's going to give you the option to add on the multi-state criminal report. You just go back through the order confirmation page and you process that report. With the criminal denial letter, it looks something like this. And again, we have a template that we will send to your office. The landlord could use this to write out with specificity the reasons for the denial if they're withdrawing that conditional offer. So to make things easier, we also do have a step-by-step. So basically, you send the link to the tenant. You're going to just order the NTN decision point report. You're going to provide it over to the landlord for review. If the landlord doesn't approve, you do this. If the landlord does approve, you do that. And that way it's step by step. So as you're navigating this process in 2022, for your first couple rentals, you can just check off to where you are in each step to make sure you're following along. And then if you do it a couple times, it'll probably just become second nature. And if you hate just seeing words on a screen, we also do have a flow chart available, which may also help because sometimes people need to see the boxes and arrows and kind of seeing exactly where this process goes, just to digest it better. And other than that, I think that's it. My contact information is here. We also have NTN client services available. So if you want to take a quick screenshot of this, or if you want to copy it down or take a picture with your iPhone or smartphone, certainly feel free to do so. If you have any questions, I know it was a lot of information, but I tried to cover more so that if there are questions that arise, you know who you can contact. Should you have any additional questions regarding anything that I kind of spoke about today. So hopefully you got that information, and I'm going to stop sharing now. I know it's a lot, so feel free to ask any questions and I'll do my best to answer them.
It's a lot. And it's a lot to put on our landlords and to ask them to follow it completely. Now they're also going to throw it back on us in that they may not want to follow the procedure. We already have the property listed for rent. We found a tenant that is putting in an application and they decide they're not going to follow the procedure. What do we do at that point?
So I think if you do have a listing that's current right now or that you just signed, I would probably get them that AG memo so that you're getting their signature on that AG memo, that they understand the laws against discrimination, the housing laws against discrimination, and also that they're going to follow the Fair Chance in Housing Act. So that would be probably step 1, is to make sure that they're agreeing to that. And the other thing is that this is a law, right? So it's not a choice. This is actually written into law. The first offense is $1,000. The second offense is $5,000. I think the third offense is $10,000 for each
Unknown caller.
oops, for each offense. So I think in that case you'd probably have to speak with Mary, your broker, about this, or management, and see whether or not you continue on with that listing. It's just like anything else. If a landlord tells you outright they're going to break the law,
then you don't do it. Yeah, but
you're licensed.
And a lot of agencies do not use NTN. And they refuse to take an NTN credit report. They want to use their own process. How do we make sure that we're covered for all these legal issues if they're not using NTN?
Is it your listing, or is it
if we have a tenant and we're putting them in, putting an application in for them for rental, and the MLS says we don't accept NTN reports. We want to run our own, or put it here or put it there. So what do we do in that circumstance so that we're protected?
Well, I think, again, this law is for the housing provider. So if they would be on that listing agent and that landlord to make sure that they're doing the right thing, right? Now, whether or not the tenant might come back and sue everybody in the transaction if something happens, that it's always a possibility, right?
Mm-hmm.
But yeah, I would think, the housing provider is the one who really has to comply with this law. So that other agency has to make sure they have the parameters in place. And maybe you could ask them too and say, well, if you're not accepting NTN, what is your process for handling the Fair Chance in Housing Act? And they could let you know. It's one of those things that it's new, so there is going to be pushback. There's always pushback with new laws, but it's a matter of making sure that you're in compliance because again, nobody has been sued over this yet. It's only a month and a half or so, 2 months old. But the first person who does get sued, they'll probably make a case out of. So you don't want to be that person.
Not to be political, but with the AGs changing how they're charging everybody with criminals, we're not going to have a classic, this level, that level, the other level, because the crime might have been more heinous, but they've dropped it down to being a virtually nothing criminal offense. So it's hard to tell. I might get out of the landlord business.
It's hard to tell. I mean, and that's what people said when the New York Housing Stability and Tenant Protection came out. A lot of my agents and companies in New York said, we're out of this. But, within 2 months, 3 months, they were back in. It's just one of those things, with rentals, there are a lot of things that you have to be aware of, but also as long as you're complying and you have a way to comply and do it in a compliant manner, then you should just be able to carry on business as usual, knowing that you're in compliance with this. Joan, you're on mute.
Okay, can you hear me?
Uh-huh.
Okay, so my understanding, if I'm correct, is that it doesn't matter what company is doing the reports, they all have to be in compliance. It's the law, so we don't have to really worry about that end of it. Regardless of what company it is, they should be doing whatever is legal,
Correct.
whatever is law. Okay, all
So
right.
you're probably going to come off two scenarios. One is people who are using NTN, because we probably screen for most of the realtors, in New Jersey at least, and but I understand there are some that don't use us. In that case, they may or may not be running criminal. Some agencies have said, well, we're not going to run criminal at all. But again, if you think about it, as I mentioned in the beginning of this call, if you don't run criminal, there is that chance that the person you screen could have an egregious or heinous crime, right? They could have murdered somebody, they could have raped somebody, they could have whatever it is. And so by removing the criminal side is in a sense, it could bring about more issues, right? Because you never know if the landlord might come back and sue because they didn't have access to any of this information. So just it'll either be that situation, or you'll run with somebody who is using NTN that does have a process in place, or maybe another service that does have a process in place. And then that way it'll be the same exact steps that we're doing now, because everybody, like you said, has to comply.
Okay.
And when we asked, when this law came out at Triple Play, actually, there was a question about, I think Barry Goodman did his legal updates. And, there were some people who were coming to our booth saying, well, why run criminal at all? So I did question Barry, and I said, is this something that, like, would you recommend them not running criminal? And he said, I would never recommend that. And the attorneys for the New Jersey Apartment Association, as well as the Property Owners Association of New Jersey, are also recommending to still continue criminal. Because there's, again, if you don't run it, there could be that one person that applies with you that does have a serious crime that could be a potential problem, and the landlord, you know, if they knew that, they may have decided to withdraw the conditional offer. So it's not enough to just say, well, we're not doing criminal at all, because then there could be a liability in the future that could come up. So
Yeah. We've had other ones show up in the past that have had murderers and all that kind of stuff on the flag. So
yeah. So unfortunately, it's just, this is the process. Everybody's learning it. Everybody's doing it now. So and don't let anybody talk you out of it either. I hear a lot of misinformation that's going around. Like, what did somebody just called me earlier and said, it's discrimination to use criminal records, right? That's what I heard. Or you're not allowed to run criminal anymore. That's what I heard. And there's a lot of false information out there. So just make sure that you stick to your guns, because this is the law that I reviewed today, and this is a process that will help to comply. But don't let them talk you out of it. It's like, you don't need to run through that. You don't need to stop for a red light. It's fine. Like, no, you do need to stop for a red light. So, yeah, but everybody is in the same boat. Everybody's trying to navigate this process, so you are not alone for sure.
Thank you. Good information.
Any other questions? Okay, I think that's it. Thanks so much. I will send over the documents so you have them.